Warning, we are not your attorneys. Please, don't take anything we say as legal advice. I'm Jeff.
I'm Mike.
And I'm Derrick.
And you're listening to the Not So Grand Jury,
which is now sponsored by Moore PLLC. All right, good day, everyone. You have 1/3 of the Not So Grand Jury here. You have Derrick, and then you have Colleen, who's back yet again. She's having an interesting arc in the Not So Grand Jury, not terribly dissimilar from Ludacris's arc on the Law and Order, which is something I didn't think I'd say out loud. But
I've never been compared to Ludacris in my life, I don't think.
Well, he does, in fact, have a 2-episode arc on Law and Order. Am I not, in fact, correct?
You are, in fact, correct.
Which is only discovered. I am this many days old today that when I discovered that. Like, I had no idea that Ludacris was on Law and Order. In fact, there's many articles about how good he was as a guest star.
No, he actually was. That's some of my favorite episodes. And actually, now that you bring it up, it is an interesting legal episode that we could maybe do in the future, because they never found the body of the person he killed.
Oh boy.
Or no, it wasn't. I forget what it was, but it was something like that. I forget if it was the body or they didn't. Nancy Grace made a guest appearance. It was Holding.
Well, listener, you have just discovered that if you hear us do an episode where Ludacris is a guest star, it's only because of this sidebar at the current moment that we decided to do it, which I think is fantastic. But we're not here to talk about that. We are here to talk more about PLCAA because, well, we talked about it in our episode that was released on May 15th, episode 16 on Runaway Jury, where Mike gave a little bit of a brief backstory on PLCAA. I'm not sure if he ever mentioned the word PLCAA because he didn't even know most of the letters.
I think I did. He did not.
Right. Right. But he did, there was a brief overview of him questioning whether the verdict that happened at Runaway Jury could in fact have happened given the PLCAA legislation. And then a few weeks later, in our last sidebar, Colleen discussed her much more personal relationship to PLCAA and the attempts she's made to help lobby Congress to have it repealed. It's only been a few weeks. We're recording this on June 15th, and there's already been multiple updates since that last release. So we are going to get into it because just recently, earlier this month, the Supreme Court first ever weigh-in on PLCAA happened in Smith Wesson Brands, Inc. versus Estados Unidos Mexicanos, also known as the Mexican government. It involved a lawsuit where Mexico sued a bunch of U.S. gun manufacturers that stems from all of the gun violence that's happening in Mexico. And let's be honest, it's not just specific to Mexico. Colleen, you can sort of weigh in on, how much gun violence is actually going on down in Latin America, and it's pretty much the U.S.'s fault.
Yeah, so relevant to this specific case, a lot of the gun violence, not only within the U.S., but also in Latin American countries like Mexico, Guatemala, El Salvador, Honduras, and Haiti, is due to gun trafficking from the U.S., especially from specific states with weak gun laws. So in Mexico, 70% of guns confiscated are American-made. In Central America, the number's around 40%. And in Haiti, which is essentially a state that is collapsing, has already collapsed. Approximately 70% of weapons recovered in Haitian operations originate from U.S. licensed dealers. Within the U.S., like the pro-gun lobby likes to talk about Chicago a lot. Illinois is a state with pretty strict gun laws, and yet they have this high gun violence rate. But that is because of lax gun control laws in Indiana. So it's trafficked from Indiana to Illinois. Also within the U.S., there's something called the Iron Pipeline, which is a pattern of trafficking guns used in crime between states that are connected via major interstate highways. So, for example, Maryland has the highest rate of crime gun imports, with nearly a third of crime guns used in Maryland that are originally sold in Virginia. And so you can see, even within the U.S., but this case we'll be talking about Mexico, how that the U.S. and specifically states with weak gun laws are really at fault here. And also just want to mention the rise of ghost guns, which are guns put together by components purchased either as a kit or as separate pieces, is becoming a huge problem on this because they're unserialized, thus untraceable. So it's hard to trace them domestically and internationally. So we're seeing that as a big problem in Mexico as well.
Thank you. So with that background, let's talk a little bit about how this case came along. So as I mentioned, the case that the Supreme Court came down with a decision only a few weeks ago was brought by Mexico. And basically, I'll give you sort of a brief overview of the complaint. The complaint is significantly longer than what I'm going to talk about, but I'll give you the very brief overview, which is that Mexico, as Colleen mentioned, has a severe gun problem, which, the government basically views as being the U.S.'s fault. Mexico only has a single gun store in the entire country and issues less than 50 permits a year. And yet about 90% of the guns recovered at crime scenes originate in the United States. Obviously there is a significant gun trafficking problem. Traffickers purchase firearms in the U.S., sometimes legally, sometimes illegally, and then delivers them to the drug cartels in Mexico. And then those groups obviously import the firearms to commit serious crimes, and help them with drug dealing, kidnapping, murder, so on and so forth. So in the complaint, which was filed back in 2021, Mexico claims that the gun manufacturers essentially failed to exercise reasonable care to prevent trafficking of their guns into Mexico, and they claim that they are responsible for all of the harms that have happened in Mexico involving guns that were purchased in the U.S. Everyone agrees, and including Mexico's counsel in front of the Supreme Court. And for those of you who've been paying attention to our podcast, I think you so fully are aware of the fact that PLCAA was designed to bar lawsuits against firearms manufacturers. Basically, PLCAA was designed to prevent firearms manufacturers from being held liable for the actions of third parties who use the guns inappropriately. But as you may remember from Mike's overview in the Runaway Jury episode, PLCAA has multiple exceptions, one of which is called the sort of predicate exception, which is where a civil lawsuit against a gun manufacturer or seller can be allowed to move forward if the manufacturer or seller knowingly violate a state or federal statute applicable to the sale or marketing of firearms, and that the their violation was essentially a direct or foreseeable cause of the harm suffered by the plaintiff. So in order for Mexico's lawsuit to move forward, they had to rely on some type of state or federal statute that the defendants have violated. Mexico relied on the aiding and abetting law. So aiding and abetting, which I'm sure many of you have heard on cop and legal shows before, I got to assume that's on SVU all the time.
Oh, yeah.
Is essentially the view that a person could be responsible for a crime that they didn't personally carry out by deliberately helping someone else complete the commission of the crime. The famous example in legal shows is the getaway driver. They always try to get the getaway driver for some type of crime. It also can be felony murder, but aiding and abetting is the sort of federal version of that. Other examples are providing weapons to someone with the goal of them committing a specific crime, or like an accountant that helped a company mislead or defraud investors. Basically, you're not committing the actual crime, but you are certainly aiding and abetting the other person in committing the crime. So Mexico files the suit in the District of Massachusetts. The defendants filed a motion to dismiss the complaint. Motion to dismiss is where the defendants are arguing that even if the plaintiff's factual allegations are correct, they still can't win the case. Here, the trial court granted the motion to dismiss. Mexico appealed. The First Circuit Court of Appeals overturned the trial court's decision and held that Mexico's complaint can move forward. And then the gun manufacturers appealed to the Supreme Court, and the Supreme Court agreed to take on the case. The decision, which just came down a few weeks ago, a unanimous court overturned the First Circuit's decision and stated that the lawsuit cannot move forward as the complaint is in the complaint's current version. Justice Kagan authored the decision. It's 15 pages long. I actually recommend you read the decision if you are at all interested on PLCAA. It's actually very well written. I do think it explains the legal issues pretty clearly, even for non-lawyers. You might get a little lost in the lingo, but I do think Kagan's decisions generally are pretty more readable than some of the judges' decisions. I'm going to try to summarize a 15-page decision very quickly, but here's the short version. Aiding and abetting requires the defendant to both take an active step in facilitating the defense, such as being the getaway driver, providing money, guns, whatever, and the defendant must intend to further the crime. Mexico's allegations against the gun manufacturers sort of generically talk about distribution systems that allow the trafficking, marketing that's appealing to cartels, general knowledge of the trafficking. But like general knowledge isn't enough. In fact, the court mentioned a case that it decided a couple years ago, which was a case involving Twitter, where basically in that case, ISIS had an attack on a nightclub in Istanbul and that killed 39 people back in a few years ago. And the relatives of the American relatives that were killed, or the American citizens that were killed, sued several of the social media companies in U.S. court, claiming the companies aided and abetted the Istanbul attack by allowing ISIS to post content that promoted ISIS ideology, things along that nature. And in that case, the court held that just having general knowledge that ISIS may be on Twitter or that some terrorist groups may be on Twitter is not enough to sort of promote the actions of ISIS or, for them to be responsible for what actually happened. They sort of relied on that for this case, basically saying that generalized knowledge wasn't enough. There are also two concurring opinions. Justice Thomas had a concurring opinion, so had Justice Jackson. Basically, concurring opinions, for those of you who are not aware, are basically where the justice agrees with the outcome of the case, but may disagree with the reasoning or wants to offer their own take on the case. Concurring opinions are not binding, but they are very persuasive. And there's a lot of examples of concurring opinions that ended up becoming like the actual law, or in fact invited people to bring certain cases in order to make the court make a different decision. And that has certainly happened over the years. Not shockingly, Justice Jackson's concurring opinion basically says that she thinks Mexico needed to give a few more definitive factual allegations, and they might be able to bring an appropriate claim. And not shockingly, Justice Thomas's concurring opinion is the opposite, where he basically says that he thinks PLCAA is even more restrictive. The exceptions to PLCAA are even more restrictive than how some of the judges would read them, but neither of which really mattered for purposes of this case. One thing I wanted to bring up is that the Supreme Court was a 9-0 unanimous decision. Interestingly enough, I don't think the general population's aware. Almost half, maybe just less than half of the cases that go in front of the Supreme Court end up in unanimous decisions. It's actually not abnormal for this to happen, but obviously all of the media attention is typically to 6-3, 5-4, 7-2 decisions, which are either on political lines or are still well fractioned in many ways. So it's not abnormal. There's a 9-0 decision, but it is interesting that this is certainly a political issue. It's just the fact that the case wasn't close, according to the Supreme Court. So wanted to bring that to everyone's attention that PLCAA is very real right now, even though, and is certainly the Supreme Court having now opined on it for the first ever time, clearly has indicated that it's, let's be honest, not unconstitutional. And they also fully believe that, it's not going away unless it gets repealed. So let's talk about that. Sounds like you're trying to repeal it, or not you, but Congress maybe.
Yeah. I mean, I think the decision is not surprising. I think the cases that we had talked about on the last sidebar really showed that just under PLCAA, there's not a lot of room for victims to bring cases like this. And in the words of some of the members of Congress who are trying to bring this forward, they're like, this is literally the only way forward is to repeal it. So Rep. Dwight Evans, who is the Philadelphia rep, has co-led the reintroduction of the Equal Access to Justice for Victims of Gun Violence Act. They love their long names of bills in Congress, along with Representatives Eric Swalwell, Jason Crow, and Mike Thompson. And there's also a Senate bill bill as well, led by Senator Blumenthal. And this legislation would ensure that victims of gun violence would have their day in court and that negligent gun companies and gun sellers are not shielded from liability when they disregard public safety. So it would repeal PLCAA, because the PLCAA, as it stands right now, does not allow victims of gun violence to bring civil suits against gun producers and sellers. And so changing the law is really the only way to let courts hear these cases, and it would provide justice to victims and their families and create incentives for responsible business practices that would reduce injuries and deaths. So as I said in the last sidebar, there has been renewed interest over the last decade in repealing the law, particularly after Sandy Hook and Aurora. And a quote from the press release of Senator Blumenthal: despite the strength and perseverance of the Sandy Hook, Uvalde, and Highland Park families and the tenacity of their legal teams, this is a problem that cannot be solved only through the courts. PLCAA must be repealed by Congress. So back in 2005, I think I also mentioned this on the sidebar, but when it first passed in 2005, supporters did insist that victims of gun violence would not be shut out of the courts. But in reality, since then, they have been. I mean, they have been dismissed on the basis of PLCAA, as we've seen in the SCOTUS case. Even when gun dealers and manufacturers acted in a fashion that would qualify as negligent. I think we mentioned some cases last time. But, I mean, it's still a ridiculous argument to me that in this specific case with Mexico, maybe it's just because it's so broad, and maybe that aligns with what Justice Jackson said, of they just needed to provide more facts. But I mean, just the fact that they know that these guns could be trafficked to Mexico. I mean, that is acting in a negligent fashion. But yeah, I guess they just needed to provide more facts on it. But in so many of these other cases, victims have been denied the right to even discover, introduce evidence. So this legislation would allow civil cases to go forward against irresponsible bad actors if it repeals PLCAA. So effectively, under the bill, the gun industry would once again be subject to the same laws as every other industry, just as it was prior to 2005. And just mentioning a quote from Representative Evans: so many American gun deaths could be avoided if we held companies accountable for things like illegal sales, defective guns, and irresponsible marketing. State attorneys general were able to hold big tobacco accountable in the 90s, and they should be able to hold gun manufacturing companies accountable in the 21st century, since thousands of lives depend on it. And so it was introduced last week. Unfortunately, we have a Republican trifecta. So without Republican support, this is likely to just stay a messaging bill. But yeah, I mean, as I said on the last sidebar, it's tough to get Republicans even on just simple legislation like storing your guns safely. And with the power and monetary influence of the gun industry on this particular issue, I think it's going to be hard. But I think, one, it's really important to try to get every single Democrat in support of this, as there have been some moderate Democrats who are not necessarily in support of certain gun control legislation. I think leading up to the midterms, we'll see how the midterms go. If, it'd be great for Democrats to grow a spine at some point. So we'll see. And I think bigger than that, the introduction of this legislation puts pressure on states to take up legislation to enact access to justice laws and repeal broad immunity laws. I think I also mentioned this on the last sidebar, but there have been a number of states who have enacted those laws, or like Colorado, for example, has repealed broad immunity laws to allow certain cases to go through despite PLCAA. So I think that's the bigger priority right now with the way that Congress is. So yeah, that's a little bit of an update on Congress and what we're trying to do there with PLCAA.
And I will say, given the fact that I've now done a little bit of a deeper dive on PLCAA, I really am of the opinion that the case in the runaway jury would not have gone forward.
No.
I don't think there's any, certainly we don't find about any facts that would be in part of the exception. Certainly not this exception. In fact, they multiple times talk about the fact that they're suing for negligence, which is kind of the purpose of PLCAA, is to prevent you just from suing under this generic, you could be responsible for being negligent, which is essentially just making the guns.
Right. Exactly.
Yeah.
Yeah, I don't think it would have gone forward.
Yeah. So I think that, again, that confirms what I believe we sort of just I think it was our sort of decision in that episode that we were pretty confident it wouldn't have gone forward. I think we tried to find ways to get around it, like maybe it was gross negligence, maybe it was other, but I just don't think that's the case. I think if that lawsuit were brought today, I'm pretty sure it's kicked out pretty early.
Yeah, and I think what you guys had talked about is that was pre-2005. So maybe back then it would have, but not today.
Right. No, I think that's right. I think that was because it was a 2003 film, as I recall correctly.
I think so.
And so I think that's correct. Like if it, at the point in time, I don't believe there was any legislation against it. And in fact, it is cases such as the one in Runaway Jury that were the reason.
Yeah, that's why the NRA sunk a lot of money into it, because things like that.
Right. And in fact, I think the majority opinion in the Supreme Court case actually mentions the purpose, like the purposes section of the statute, which was to prevent manufacturers and sellers from being held liable for the harm caused by those who criminally or unlawfully misuse firearms, basically saying they make the firearms. It's up to you, go after the person who does the bad thing.
Right. Yep.
Cool. Well, that's an update for our audience on stuff we've previously discussed. Obviously, it's just another way to get Colleen involved until her arc comes to an end. And then we have to find a new arc for her to jump in on.
Yeah.
But,
I wonder what my second coming will be.
Well, I'm sure you can find something. Again, we've given you carte blanche to come back, so I'm sure you'll find a way to come back in.
Yeah, what's the ludicrous reference? Does he have some kind of... I'm realizing I've been called both ludicrous and Dick Cheney on this show, so that's a weird... it's weird.
Well, welcome to the Not So Grand Jury.
Yeah.
Completely normal things that happen here. All right, good times, and expect another fun episode coming out next week.
Great, thanks.
The Not So Grand Jury is sponsored by Morwa PLLC.
The opinions expressed in the Not So Grand Jury are those of the hosts themselves and not of their respective employers.
The theme music for the Not So Grand Jury is from Gustav Holst's Jupiter and is in the public domain.
If you'd like to get in touch with us, if you want to suggest future movies, or even if you want to offer corrections, you can email us at notsograndjury@gmail.com or message us on any of our social media accounts.
The Not So Grand Jury is copyright 2025, all rights reserved.